Planning to start a startup? Hear this out. Hello ma'am, thank you for coming ma'am. So, let me put a hypothetical situation to you ma'am. Friends are starting a company and these friends have complete trust between them. Do they still need a founder's agreement or is it just a legal overkill?
That is exactly when you need an agreement in place. Agreements are not about mistrust. They are about clarity. They are about avoiding disputes or disagreements in the future. Agreements, when everyone is aligned or optimistic, that is when you should document your expectations. Think of it as setting the rules of a game right at the beginning when you're about to start the game seriously. One of the biggest misconceptions early stage businesses have is when is the right time to start the legal work. Is it when the investor wants to come in? Is it when the dispute or the disagreement has arisen? Or is it when the company is large enough to have formal systems in place? In fact, most of the serious legal problems do not arise at the point of crisis. It arises much early on, when the businesses are set up loosely, when the relationships are undocumented, when your ownership or relationships or responsibilities are assumed. It is very, very important that's the reason you must have your agreements in place right at the beginning. Think of it as early stage tools rather than later stage formalities.
Alright ma'am. Now say one of them leaves the company in 6 months. What happens to their share? Do they still have it or lose everything?
So this is where vesting becomes critical. Vesting essentially means that founders earn their shares over time, not upfront. Think of it as buying a car on EMI. You truly own it once you have paid it off. Same idea goes here. The usual shape is the founders earn their share over a period of about 3 years with nothing in the first year. So when someone leaves, they only leave with what they have actually earned. But without a vesting mechanism in place, our leaving founder can walk away with a disproportionate stake despite their limited contribution.
Okay, so vesting is indeed important. But let me put you a more difficult scenario. If a co-founder is asked to leave for a misconduct, do they still retain their equity?
Well, that depends on the agreement executed with the company. A well-drafted founder's agreement must have, a situation of a good leaver situation and a bad leaver situation. A good leaver situation is when your co-founder is exiting on fair terms. It could be termination without cause or circumstances beyond his control. It could be death, disability, etc. In that scenario, it is likely that either the shares are retained by him or they are fairly compensated for the shares. Whereas in a bad leaver situation, that would cover situations where the co-founder is exiting, or it can be a breach of a contract, it could be fraud, misconduct, any kind of termination with a cause. In that scenario, the shares are normally transferred at a discounted rate or even forfeited.
And none of this is documented. Then what happens?
Then the default position applies, which is often the most problematic one. The departing founder may retain full ownership of their shares despite their misconduct. And this is precisely the risk founders underestimate when they skip formal agreements.
For more such informative videos, follow Vakeel Saab.